Hello and welcome to today's Vorys webinar. Thank you for participating in our discussion this afternoon entitled Cybersecurity and Coverage Issues. Before we get started, please review your screen to be sure that you see the following items. Presentation slides on top and 2 pods below, one for downloadable program materials, one for related websites, and a private Q&A box to the right. All pods can be accessed throughout the presentation without interruption to the program. We encourage you to click into these links and documents for additional insight. Please note that the participant phone lines will be muted throughout the duration of the presentation. We encourage you to mute your own line as well via the Mute My Phone button on your screen or directly on your phone. Attorney CLE credit is pending for this program. If you would like to submit your attendance, please download the CLE form in the Materials pod, enter the attendance code that you will see during today's program, and complete the required fields and submit as indicated on the form. Your hours will be submitted on your behalf by Vorys. We will offer time for questions at the conclusion of the presentation. Please submit your questions through the private Q&A box throughout the duration of the presentation, and they will be addressed towards the end. And now for opening remarks and introductions, I'd like to turn the call over to Heather Enlow-Novitsky of counsel with Vorys, Sater, Seymour & Pease.
Good afternoon, everyone, and thank you for joining us today. We've got a great session here on updating you on cybersecurity, regulatory actions, enforcement, and breach litigation, as well as a discussion on cyber coverage. So we'll go ahead and get started. And again, we appreciate everyone joining us today. So first, we're going to discuss some regulatory updates related to cybersecurity, an enforcement update. We'll talk about some breach litigation and where that stands. And finally, we'll conclude with some cyber coverage issues. So first, why cybersecurity? Why does it continue to be such a hot topic? Why does it continue to be such a focus for regulators? For some examples, the Identity Theft Resource Center recorded 1,293 data breaches in 2017 alone, exposing more than 174 million confidential records. Now, of course, we know most of that was exposed by one party, Equifax, but still, that's a lot of records. You'll see banking, credit, and financial companies made up 7.1% of those breaches. And interestingly, according to the U.S. Census, there's only 125.8 million U.S. households, so there was more records exposed in the U.S. than households. And finally, also last year, the dark web database was discovered with over 1.4 billion email addresses, usernames, and passwords, exposing legitimate credentials of billions. And interestingly, the data, the amount of breaches that happened in 2017 was 21% higher than 2016, whereas 2016 recorded 1,093 breaches. So this just continues to get worse and worse. Cybercrime is expected to cost the world $6 trillion every year by 2021. Ransomware alone is predicted to top $5 billion globally by the end of 2017, which is 15 times the damage in 2015. So this particular attack mode has been a significant amount in increase in costs. The average price right now that hackers or others can obtain for stolen account credentials is $15 for a pair of credentials for well-known e-commerce and banking sites. And finally, the global cybersecurity industry, everyone trying to combat this, pulled in $120 billion last year, which was 35 times more than they did in 2004. So a lot more investment being put on the security side, and this is expected to just continue to grow exponentially, especially as further regulations like the EU's GDPR come into effect later this year. So given all of that, we know that there's a lot of regulatory attention on this issue. So for fiscal year 2018, the OCC did identify cybersecurity as one of its top areas of focus. The fiscal year for the OCC began October 1st of last year, and it goes through September 30th of this year. Other top areas of focus included commercial and retail credit loan underwriting and the allowance for loan and lease losses, business model sustainability, and BSA AML compliance management. The OCC stated that they'll review the bank's programs to determine to what extent they assess the evolving cyber threat environment and their cyber resilience and how they're managing those risks. They also recommended the continued use of the Federal Financial Institutions Examination Council's Cybersecurity Assessment Tool. The Federal Reserve, the Federal Vice Chairman for Supervision made similar remarks recently on February 26th at a conference for the Financial Services Roundtable. He stated that cybersecurity continues to be a high priority for the Federal Reserve and that they're really committed to strategies that will result in measurable enhancements to the cyber resilience of the entire financial system. He also encouraged the sharing of threat information through the FFIEC, and also they emphasized the importance of using the FFIEC cybersecurity assessment tool. So the FFIEC cybersecurity assessment tool, the CAT, was updated last year in May. Again, the goal of the tool is to help financial institution management determine that institution's risk profile, inherent risks, and cybersecurity preparedness. Its goal is to provide a repeatable and measurable process to measure cybersecurity preparedness over time. It is stated to be a voluntary tool, although there's been some debate, of course, about whether it actually is voluntary. So the updated assessment was addressed to change the changes to the FFIEC IT examination handbook by providing a revised mapping in Appendix A to the updated information security and management booklets. The 2017 update unfortunately wasn't the sweeping overhaul that some had been expecting or hoping for. For example, the inherent risk profile and cybersecurity maturity declarative statements remain unchanged, which can be problematic. But it did include two helpful changes. One, the first being the Appendix A mapping update, which correlates to the baseline maturity controls in the booklets we discussed. It's updated to reflect the changes in the information security and management booklets issued in 2016. And the second major update, the helpful update, was the addition of compensating controls. So it changed. Now you have the choice to answer cybersecurity maturity declarative statements with yes with compensating controls as opposed to a previous yes or no option. It defines a compensating control as a management, operational, or technical control employed by an organization in lieu of a recommended security control in the low, moderate, or high baseline that provides equivalent or comparable protection for an information system. This change has helped transform the nature of the tool from a more basic black and white approach to one, there's shades of gray now, allows for some more flexibility. And so as a result, we should be looking at how you've answered the declarative statements and the maturity assessment portion of the tool before and identify any areas where there may have been compensating controls in place that you weren't allowed to acknowledge previously to close previous gaps. And this could allow achievement of a higher level of maturity than in prior assessments using the tool. So another significant cybersecurity-related update from the regulators is from the FCC. On February 24th, the FCC issued an update to their 2011 cybersecurity disclosure guidance. The guidance highlights the need for cybersecurity disclosures based on current reporting obligations and the materiality standard, identifies specific cybersecurity risk factors, and emphasizes two new areas of focus considering the adoption by public companies of appropriate policies and procedures to address cybersecurity matters and to enforce insider trading prohibitions. In the new guidance, there's a new emphasis on the importance of having comprehensive policies and procedures in place when it comes to reporting cybersecurity risk and incidents, and also on the obligation of companies to not selectively disclose or trade on material non-public information about cybersecurity risks and considerations. The guidance notes that currently the disclosure requirements do not specifically refer to cybersecurity risks and incidents. The obligation to disclose such risks and incidents arises out of a number of their requirements based on a company's particular circumstances. This includes disclosures in periodic reports, such as the annual Form 10-K, including within the management's discussion and analysis section. The materiality standard may trigger disclosure obligations related to cybersecurity risks and incidents. And rather than implementing one standard specific to cybersecurity, the materiality determination remains a fact-specific inquiry. The guidance notes that the materiality of cybersecurity risks or incidents depends upon their nature, extent, and the potential magnitude, particularly as they relate to any compromised information or the business and scope of company operations. So factors to think about when making an assessment is to think about the range of harm that such incidents could cause, both to a company's reputation or their financial performance or their customer and vendor relationships. Also to evaluate the possibility of litigation or regulatory investigations or actions, including actions by state and federal authorities as well as non-U.S. authorities. They also provided guidance on the timing of the disclosures that are required. The timing of cybersecurity incident disclosure is a critical balance between a company's desire to provide swift disclosure and the importance of ensuring that the essential facts are understood and the disclosed information is accurate. So they acknowledge that there's two competing interests going on here about when you're going to make the required disclosure. Depending on the nature of the cybersecurity incident, some reasonable amount of time may be required to determine its scope. They recognize that a company may require time to fully understand the scope of the incident. It also may be affected by requests from law enforcement to cooperate with an ongoing investigation. And considering the timing issue, the guidance observes that an ongoing internal or external investigation cannot provide a basis for avoiding disclosures of a material cybersecurity incident, but they can impact as to when that disclosure is going to occur. For the first time, the guidance makes clear that companies have a duty to correct disclosures that are determined later to have been untrue when originally made, and may have a duty to update disclosures that were correct when made based on later material information, such as when reasonable investors are still relying on the disclosure. In particular, companies should consider whether they need to revisit or refresh previous disclosures, including during the process of investigating a cybersecurity incident. So the FCC, when you're thinking about the timing of this disclosures, they do expect that you have an ongoing obligation to update your disclosures as appropriate. So the guidance updates several cybersecurity risk factors to consider about what is material and what needs to be disclosed, such as the occurrence of prior cybersecurity incidents, the probability of future occurrences and their consequences, the adequacy of the preventive actions and controls that you've taken to reduce the risks, as well as the costs, aspect of your business and operations that give rise to the material cybersecurity risks and the potential costs and consequences, the potential for reputational harm, existing or pending laws and regulations that may affect the requirements, and finally, litigation, regulatory investigations, and remediation costs associated with cybersecurity incidents. Now, a lot of this was further clarification of the 2011 guidance, and in many places had already been stated. But now we're really getting into the new requirements or the new expectations of the FCC. This is really the first time they've emphasized that the companies need to have policies and procedures in place to report cybersecurity risks and incidents. They also need to include appropriate and effective disclosure controls and procedures that enable companies to make accurate and timely disclosure of material events, including those related to cybersecurity. And senior management should receive sufficient information about cybersecurity risks and incidents to enable them to make disclosure decisions and execute necessary certifications. The second area highlighted by the FCC in the updated guidance is the need for companies to abide by insider trading prohibitions when it comes to cybersecurity incidents. The FCC expects companies to take steps to prevent directors and officers and other corporate insiders who were aware of the cyber incident or risk matters from trading its securities until investors have been appropriately informed about the incident or the risk. They emphasize the role of well-designed policies and procedures to prevent trading on the basis of all types of material non-public information, including information related to cybersecurity risks and incidents. So this is really the first time that the FCC has made clear that they expect insider trading policies and procedures to apply to cybersecurity risks and incidents as well. And we'll come back to that new guidance in a few minutes. But quickly, we'll move on to the New York Department of Financial Services. Their rules now in effect. The first compliance date for the cybersecurity rules was August 28th of last year, and they phased in timing of the various requirements under their regulation. Recently, on February 15, was the first certifications required of financial institutions' compliance with the regulation. And March 1st was another phased-in approach of requirements where companies had to have their risk assessments and similar safeguards in place. They had to have implemented multi-factor authentication and encryption where appropriate. They were to implement cybersecurity training for their personnel, penetration testing and vulnerability assessments, as well as the CISO needs to be reporting annually to the board of directors. There has been no enforcement actions yet, but the regulators at the New York Department of Financial Services have stated that they have reserved the right to add questions to the first day letters that they may be sending to financial institutions in response to their certifications made by February 15th. Helpfully, they've also made FAQs available on its website that are frequently updated, both about the requirements that are currently in effect and the upcoming phased-in final requirements. Full compliance with the regulation is expected by March 1st of next year. So now we're going to, so now we have a code for the CLE credit. It's Thursday 15. Okay, and we'll move on now to the enforcement update. So going back to the SEC, in September, they had announced the establishment of a cyber unit designed to target cyber-related misconduct, and that cyber unit brought its first case on December 4th of last year. The SEC complaint alleged that a company operated an initial coin offering fraud that raised over $15 million from investors by selling a security called PlexCoin, a cryptocurrency, and promising 1,354% profit in less than 1 month. It's a pretty amazing rate of return there. The charge files against PlexCorp and the partners LaCroix and Paradis Royer included violations of the anti-fraud provisions contained in the SEC Act, as well as registration provisions in the Securities Act. After filing the charges, the district court issued an immediate emergency order freezing the assets of the company and the executives charged, and the SEC is seeking a permanent injunction and disgorgement plus interest and penalties against both the company and the founders. They are also seeking a final judgment prohibiting the two executives from offering digital securities in the future. And now coming back to the FCC disclosure guidance that I was just talking about, they wasted no time in making their first insider trading charges in connection with a data breach. Yesterday, the FCC announced that the former CIO of Equifax has been charged with insider trading in connection with its 2017 breach. In a statement, they said that Ying used confidential information to conclude that his company had suffered a massive data breach and dumped his stock before the news went public. He was charged with violations of the anti-fraud provisions, and they are seeking that he disgorge an amount equal to the losses that he avoided by selling his stock when he did, plus interest, as well as pay a monetary penalty and be prohibited from serving as an officer or director of a public company in the future. The FBI also brought charges against the CIO of Equifax yesterday. So again, we're looking at policies and procedures if you are a public company to make sure that insider trading rules apply to folks who may be involved in cybersecurity incidents. Turning to another regulator, the Federal Trade Commission, they brought an enforcement action and announced a settlement with PayPal on March 5th. And this was related to PayPal's Venmo service that it acquired in 2015. It charged PayPal with violations of the privacy and safeguards rules under the Gramm-Leach-Bliley Act, and they charged PayPal committed deceptive acts or practices in violation of the FTC Act. So what did they do? Venmo, which was acquired by PayPal in 2013, offers peer-to-peer payment services to consumers via an app and on the web. Through the service, consumers can link external credit card and bank accounts to their Venmo account, receive into their account their Venmo accounts funds from other consumers or from other linked external accounts. And they can also transfer funds from their Venmo account to linked external accounts. So very common features of many peer-to-peer type payment services. It was marketed as a method to make payments to and receive payments from anyone. So the FTC alleged that Venmo made representations to consumers, both on the app and in its advertising, that consumers could transfer funds out of their Venmo accounts to a linked external account in as little as 1 day or overnight. But they, in fact, waited until a consumer initiated a transfer request to begin the clearing process, and often either delayed the transfer for several days or outright blocked it, or they could still reverse the deposit transaction, and frequently they gave no notice to consumers when they did this. So consumers would get a notification that the funds were available without realizing that they weren't truly unilaterally available. And this caused consumers to potentially pay out the money to someone else, and then it was reversed, and then they didn't have the money in their account anymore, or that would cause them to incur fees and similar type issues. The FTC alleged that Venmo had actual knowledge that consumers did not understand its practices on holding funds or reviewing them because of the multiple customer complaints and inquiries they received, yet they continued their practices without any additional disclosures to consumers or actually even really explaining to consumers how it happened. So in addition to misrepresentations they made about the availability of funds, the FTC also focused on Venmo's privacy practices. So by default, consumers' activities were posted to the app's social networking feed and made publicly available to anyone on the internet. Users are able to change these settings, but it was often a confusing and multi-step process that, even if done correctly, could be overridden by the other party to the transaction. So for example, a consumer could believe that she had changed her settings so that receipt of a payment would be visible only to her, but if the payor chose to make the payment public, the payment would be shown on the payee's feed despite her privacy election. This could also happen retroactively, so that a consumer could elect the most private option for all transactions only to have that election overridden by a third party or by the payor in a future transaction. There were ways to prevent this, but it required a consumer to follow several steps that were not clearly explained. In fact, according to the FTC and Venmo's FAQs, provided incorrect information to consumers about how to ensure the privacy of a transaction. They also failed to send initial clear and conspicuous privacy notices to consumers in that the notices they did not find they were clear and conspicuous because they were accessible via links which were printed in dark gray typeface against a light gray background. So hard to see visually where they were. They were inaccurate because the default settings made all information public while the privacy notice implied the opposite. And they were not delivered reasonably because a consumer could create an account without acknowledging receipt of the privacy notice. Third, the FCC took issue with Venmo's security representations. They represented on its app and website that it employed bank-grade security systems and data encryption to protect financial information. And the FTC alleged that at least until March of 2015, this representation was false. They failed to provide security notices about account changes, such as password changes or a new email address being assigned to the account, which allowed hackers to take over accounts. And they failed to have a written information security program, as well as failed to assess reasonably foreseeable risks and adequately investigate consumer reports of compromises of their accounts. So all of this led to a settlement. It is currently out for public comment. It has not been finalized. It prohibits PayPal from misrepresenting material restrictions on the use of its services, the extent of control offered by privacy settings, and the extent it adheres to a particular level of security. It also imposes biannual assessment requirements by third-party auditors of its compliance with the settlement, as well as information security program requirements for the next 10 years. So I'll now turn it over to Chris to give us a litigation update.
Thank you, Heather. And I just want to highlight some recent developments in litigation in the data breach space. 2017 continued the trend from prior years with high-profile data breaches resulting in immediate class actions. Litigation in this space has become reflexive. As soon as you see a headline with a class action complaint, surely to follow right behind it. We saw class actions filed in just about every industry that you could think of, and I did want to include the deep-root class action on this slide just to prove that just because class actions are filed for more than against companies that have red in their logos. One class action that stands out, or one data breach that stands out among all others, of course, is the Equifax incident. And to date, more than 240 class actions have been filed involving that incident. Of note, the Massachusetts Attorney General filed a direct suit for violations of its state's data privacy statute, which includes very specific data security protocols and procedures. And additionally, both the cities of San Francisco and Chicago also filed separate suits, here again trying to insert themselves in this space. So now we are starting to see cities jumping into the litigation fray. I wanted to highlight a couple cases of interest. And the first case I wanted to discuss is the Noodles and Company incident. It stems from a class action brought on behalf of several financial institutions. You'll recall that in early 2016, Noodles and Company announced that customers' credit and debit card information had been compromised in several hundred of their restaurants in the states of Colorado, Oregon, Ohio, Indiana, and Iowa. Now, several credit unions filed suit in the District of Colorado, alleging negligence theories. And why negligence, you may ask? And as I've copied and pasted from the judge's decision, the issuing banks in this case, or the credit unions who were the plaintiffs, did not have direct contractual privity with Noodles and Company, the merchant. So instead of alleging any kind of breach of contract because there were no contracts between the credit unions and the merchant, they framed their claims under negligence and negligence per se, much like we've seen with other financial institution cases such as Home Depot. And the damages that the credit unions pursued are exactly what you would expect to see, ranging from costs related to the reissuance of cards, opening and closing affected accounts, costs for increased fraud monitoring or investigating alleged fraudulent charges, and even including damages due to the lost revenues from customers' loss of use of their accounts while they were waiting for their cards to be replaced. Now, what's interesting here is Judge Jackson, the district judge, dismissed the claims, holding that the economic loss rule barred all of their negligence theories. The credit unions tried to argue that there was an exception to the economic loss rule that would allow for any kind of claims to go forward where there was a breach of a duty that was independent of any contractually related duties. However, Judge Jackson disagreed. He looked at the Noodles and Company contract, which incorporates the card brand rules. So, for example, the Visa and MasterCard rules, which would require Noodles and Company to follow PCI DSS. And Judge Jackson concluded that any of the alleged damages or breaches would have stemmed from a violation of Noodles and Company's contractual obligation to comply with PCI DSS. Therefore, the exception to the economic loss rule could not apply. Now that is directly opposite from what happened earlier in the Home Depot case. You may recall that there's a financial institution class action filed after the Home Depot breach, and in that case, the district court held that Home Depot had an independent duty to the world, and I'm paraphrasing, to have sufficient data security protections in place, and as a result of that independent duty, the economic loss rule simply did not apply. So there is, between these two decisions, you have square contradictions that will need to be sorted out as these cases continue to be litigated. Next, I want to briefly cover a case filed by Microsoft. And in this case, Microsoft used an internet brand protection litigation strategy to its benefit. Now, Microsoft filed suit seeking an injunction that was not necessarily aimed at bringing hackers or individuals to court, but rather in order to seize domain names that were used to control malware on infected computers bearing Microsoft's names and products. So basically what was happening is Russian hackers who operate by the name of Fancy Bear distributed malware to computers across the globe, and the malware was programmed to beacon back to the hackers' servers, sometimes including information that the hackers were attempting to steal. Now the hackers routed this traffic through internet domains, and in this case they were using internet domain names that look very similar to Microsoft's real domains, such as, for example, livemicrosoft.net. Now as a result of this suit, the hackers didn't show up in court, so a default judgment was entered against them. And the district court entered an injunction against the hackers' continued use of any similarly named domains, and transferred control of those domains to Microsoft. So once these domains were under Microsoft's control, they were able to redirect the traffic to Microsoft, cutting off the hackers' ability to have any impact on malware victims. And it essentially, to date, has enabled Microsoft to take over 70 different servers that the hackers were using. Now, online brand protection is an emerging area of the law, and we here at Vorys literally have an entire department who assists many of our clients in protecting their brands and products online. And this Microsoft case is a good illustration of how our court system can be used as a low-cost sword to protect both the company's brand and its products. The next case, the Beck case, comes to us from the Fourth Circuit involving a veterans hospital. It stands out because, believe it or not, it just involved a stolen laptop. Now, I wanted to cover that today because that's a somewhat frequent occurrence for many of our clients. We're often asked to assist with handling situations where devices containing regulated data come up missing. And this particular decision provides a helpful analysis for assessing potential exposure in civil litigation whenever you have a missing asset. Here, there was a laptop, again in a veterans hospital, containing unencrypted personal information of approximately 7,400 patients. And as you can imagine, there was pretty sensitive information contained therein. Now, the hospital's internal investigation determined that the laptop was likely stolen and that the hospital failed to follow its own policies and procedures for utilizing a non-encrypted laptop to store patient information. Now, however, every patient who was impacted by this or whose information was on that laptop was provided direct notice by the hospital and was offered 1 year free credit monitoring. Now, of course, A class action was brought on behalf of the patients against the hospital for various statutory violations and negligence. And at the motion to dismiss stage, the court did dismiss the negligence claims, but did permit the suit to go forward. And you'll note, standing is a very hotly contested affirmative defense that's been litigated post-Spokio, and that particular topic would take an entire hour just in itself to cover. But what's interesting about this case is the standing issue really came to bear at the summary judgment stage. So not through a motion to dismiss after the complaint was filed, but actually, in this case, discovery went all the way through to the end. And as a result, the defendants, the hospital, got another bite at the apple and moved for summary judgment on Article 3 standing. And the court noted that, once you get through discovery, the plaintiffs actually, they have to come forward with direct evidence showing that they have suffered a concrete and particularized harm, and that their damages are actual and not not speculative or conjectural. The court noted that there is a circuit split on what it takes to qualify for standing. However, in this case, again, it's a little unique because it was at the summary judgment stage. The court looked to the plaintiffs and said, okay, hey, it's been a few years now. What damages do you have? And they were, the plaintiffs were unable to show actual instances of identity theft that were caused by this incident. And the court also pointed out that they could not prove that whoever stole this laptop stole it with the intent or the purpose to obtain the patient's information. For all anyone knew, the bad guy or whoever stole the laptop just wanted a laptop. And so the court held that there was no standing as a result. And next, I want to move to what at least for many of us who are involved in internal investigations and incident response, there are three cases that came out this past year that provide helpful guidance to ensure that both the attorney-client privilege and work product doctrine protections are maintained throughout the course of investigation. Now, the first case stems from the Experian intrusion and subsequent class action. You'll recall in fall of 2015, Experian learned that one of its systems was breached by an unauthorized third party. Immediately after Experian realized this, they retained outside counsel for legal advice regarding the intrusion. Now, outside counsel hired a forensic investigation firm to conduct an expert analysis of the attack. And according to that forensic investigation firm, the only purpose for their analysis was to assist outside counsel to provide legal advice to Experian about the attack. Now, of course, it was discovered in the litigation, Experian had a contractual obligation, though, to remedy the intrusion and to remediate it. So the plaintiffs in this case argued that, wait a second, this forensic investigation firm was really really hired to assist with remediation for a business purpose and not solely for the provision of legal advice. The court, however, looked through the various statements of work and the correspondence and concluded that it was clear that the forensic investigation firm prepared its report for outside counsel in anticipation of litigation. So while there may have been some remediation that followed as a result of that investigation and that report, the primary purpose was to assist the outside counsel. And another key point there too is the forensic investigation firm's report actually was not finalized until after Experian provided its breach notification, and after then the class action complaint was filed. And so the court did look at who all received the report. The forensic investigation firm's report was shared with outside counsel, and then outside counsel gave that report to Experian's in-house counsel. And those were the only folks that saw it. And so the court said, it's clear, the court was satisfied that this report then was really for the purpose of advising counsel, so that counsel could provide Experian with legal advice regarding the intrusion. Therefore, it was the privilege was maintained. Now, I wanted to cover two other cases where an opposite conclusion was reached. First, in a Sixth Circuit decision, the Sixth Circuit actually affirmed a decision of where waiver occurred, and in that class action, it involved a mortgage company whose database containing borrowers' information was hacked. The mortgage company answered an interrogatory and discovery stating that their investigation, their internal investigation, concluded that the intrusion was caused by a co-defendant. And in their answer, they included an affirmative defense that the co-defendant was a cause of the intrusion. Now, given the allegations and this affirmative defense, the co-defendant then served discovery on the mortgage company, asking for its forensic firm's investigation files and correspondence related to that. And the Sixth Circuit looked at that and said, well, mortgage company, you can't hide behind the privilege if you're relying on the privileged communications to make your case. You can't use privilege as both a shield and a sword. And so once the conclusions of the investigation, i.e. that there was another cause, a co-defendant of the intrusion, that is subject matter waiver. And mortgage company, you are hereby required then to produce all documents related to that investigation. The next case is out of the District of Oregon, and it's related to the Primera Blue Cross Blue Shield data intrusion. In that case, the interesting thing is first, Primera, the company that suffered the intrusion, hired directly a forensic investigation firm. And so they started the investigation into what happened. And once they realized that there was a serious issue, then Primera brought on outside counsel. And as soon as outside counsel got involved, they retained the same forensic investigation firm. However, the scope of work for the forensic investigation firm's work didn't change at all from what they were retained by Primera to do. And so when the court looked at that, the court said, well, at first, it seems like the forensic investigation firm was hired to or for a business purpose, i.e. to figure out whether anything happened and or to remediate any problems. And once you brought on outside counsel, it's not clear, because the statement of work didn't change at all, that the investigation firm was really there to provide outside counsel with information to advise the company on its legal exposure. And another wrinkle in this case is that outside counsel also brought on a PR firm, and they tried to invoke both attorney-client privilege and work product related to the communications with their PR firm. And the court said, no, you can't have a blanket protection here. We're going to have to go document by document and email by email to see if the communications were really pertaining to legal advice or whether it was for a business purpose just to get a press release out. So very interesting cases there. I wanted to quickly cover some of the settlements that came through. You guys will all remember, of course, the Target data breach where there were 40 million payment cards involved. To date, Target has entered settlements totaling around $135 million. And if you just use rough math, 40 million cards, $135 million, that comes to about $3.37 per card. But that's just through various entities. And that's pretty much the high watermark that you'll see over time. The reason why this is still relevant is, the consumer class action was tentatively settled in 2015. However, that settlement's been delayed based on objectors. And we did see last year, in 2017, the settlement with the state attorneys general, a collective group of its state attorneys general, for $18.5 million. Other big settlements, the Anthem intrusion involving about 78.8 million affected individuals. There was a single settlement for the consumer class action of $115 million. So that would come to about $1.45 per affected individual. Now again, a little bit different information though involved than payment card information, but some items that stand out in that settlement, almost 38 million of it was for attorney fees. The company did agree to reimburse out-of-pocket costs, to provide additional credit monitoring, and to change its data security practices that would then be audited by an independent third party. Likewise, in the Home Depot settlements, we're seeing approximately $38 million there. And interestingly, that is vastly lower than the Target settlement, because that comes out to with 50 million approximate cards involved, comes out to about 76 cents per affected. One thing to point out here, in addition to the consumer class and financial institutions settlement, there was a shareholders derivative suit, and that settlement was for $1.1 million. But note that the Home Depot obtained a dismissal on that shareholders derivative suit, and then the case was settled while the appeal was pending before the 11th Circuit. Here very recently, there was a settlement in the Yahoo intrusion. You'll recall that Yahoo suffered 2 data breaches in 2016. A shareholders derivative suit followed, and the shareholders derivative suit settled for $80 million. Now here in this case, the plaintiffs were able to tie the timing of the data breach and the data breach notifications with a significant drop in value of Verizon's acquisition of Yahoo. Because Verizon announced that as a result of the data breach, they were cutting $350 million from the acquisition price. And so, that may have impacted the value of that settlement. However, it's notable because, plaintiffs and shareholder derivative suits have not had much luck. So this may inspire a lot more litigation on behalf of shareholders. Because we've seen, for example, in Target, Home Depot, Wyndham, very early dismissals in those cases. I've also got on here a couple other settlements. The Ashley Madison consumer class of 37 million users. That settled for $11 million or 30 cents per affected. And I wanted to also mention the nationwide mutual insurance settlement. And that settlement was with the state attorneys general from 32 states. There's a $5 million hit to the company. But the one thing to note here is it also included the implementation of rigorous data security practices and procedures, and particularly procedures related to patch management. You'll recall that some very high-profile data breaches like the Equifax breach stemmed from inadequate patch management. And so the regulators, or at least the state attorneys generals, provided somewhat of a roadmap for those kinds of programs that they'll be looking for in the future. So with that, I wanted to next discuss coverage issues. Heather?
Thanks, Chris. So the cybersecurity insurance market, it's still a pretty young market. There's a lack of standardized terms across insurers, and it can make it challenging to know what you have or what to invest in because due to the lack of standardized terms, really have to evaluate the specific provisions of each policy as you're facing a decision on whether to buy cyber insurance or renew. It is expected, however, to experience massive growth this year. This anticipated market expansion is based on persistent cyber threats, as well as new state, federal, as particularly international regulatory schemes, with, again, the GDPR coming into effect. The total annual cyber premiums are expected to rise from $2.5 billion last year to $10 billion by 2020. And some of the reasons why this is expected to go up is just the continued web of regulatory requirements that just continues to get trickier and added to the pervasive and increased change and always changing nature of cyber risks, data breaches, and the related litigation that Chris just covered, especially now that actions are starting to have more success, and other privacy-related litigation, such as the Biometric Information Privacy Act in Illinois and related litigation, as well as TCPA litigation, where statutory damages are available and plaintiffs are having easy success in class actions and securing high-dollar settlements. So all of this is contributing to the market. So most standard commercial line policies do not cover many of the cyber risks that we've been discussing. So insurers compensate for a lack of actuarial data by relying on qualitative assessments of an applicant's risk management procedures, as well as their risk culture, to customize policy. The underwriting process can help identify cybersecurity gaps and opportunities for improvement, and they may be value added through inclusion of risk mitigation tools, as well as incident response assistance. They will likely evaluate your disaster recovery plans, the risk management of your networks, the website, physical assets, and IP, review how employees and others are able to access the data systems, as well as question the types of antivirus and anti-malware software used, and the frequency of updates, patching, and the performance of firewalls. So what are some types of coverage to consider and negotiate for? Again, what is covered varies dramatically across policies, so you really need to get in the details to see what you're getting. So you want to look for liability for security or privacy breaches, including loss of confidential information, not by allowing or failing to prevent unauthorized access to the computer systems, the costs associated with a privacy breach, such as consumer notification, providing credit monitoring, customer support, call centers, if you have to outsource it, forensic investigation costs, and specifically if you're dealing anything with the card brands, if you issue cards and there might be a breach in your production environment, for example, anything in specific related to card brand costs, anything coming through the card brands is frequently specifically excluded unless you negotiate for it. The cost associated with restoring, updating, or replacing business assets, business interruption loss, and extra expense related to security or privacy breach, expenses related to cyber extortion, particularly with the popularity of ransomware or cyber terrorism, coverage for expenses related to regulatory compliance and investigations. One hot topic is if one of your employees falls for a phishing or fraud scam that then it appears to them, let's say it's an authorized payment to a vendor and they send the money out the door, is that covered by your cyber insurance policy? Do you have coverage for those specific types of incidents? And privacy liability is another more severe coverage to be aware of. So claims from third parties resulting from failure to handle data or confidential business information properly and unintentional violations of privacy regulations. More and more insurers are requiring notification early on. So one thing you have to think about with your policies as you're evaluating them is what happens if a breach is not discovered for an extended period of time. Is there requirements on when you have to notify? Is it upon discovery or when the breach actually starts? And is that a risk if something is happening for a while and your organization is not aware of it? So policy disputes continue to be a hot topic. A recent case came out in June last year. Now this was a dispute over a CGL policy concerning a TCPA claim, a Telephone Consumer Protection Act claim, which is a very hot area of litigation. The CGL policy contained an endorsement for personal injuries due to improper data disclosures that violate a right of privacy. The court, however, distinguished between the two meanings of a right to privacy, a right to secrecy, which is the content of the communication, and the right to maintain seclusion, which is the method of communication, and ended up ruling that no coverage existed for invasion of privacy that occurred when unsolicited messages were sent to intended recipients. So the CGL policies can be challenging to get coverage in this space. Finally, some cases to watch in this area. In Harvey versus Geico, this is down pending in the Florida Supreme Court, is to decide whether an insurer can be held liable for a bad faith failure to settle. And that's definitely being watched across the industry. Rosen Millennium versus St. Paul, it's in a Florida District Court. Now this case is going to determine whether a traveler's unit has to cover a hotel operator's cyber attack losses under two different CGL policies. So whether cyber attack losses at all have to be covered under CGL policies has been a hot topic, and this is another case that will provide some guidance there. And finally, Income versus Great American Insurance Company. This is up at the 11th Circuit, and they're going to decide whether a processor of prepaid debit cards is entitled to coverage for $11.4 million loss related to a fraudulent redemption scheme. This actually started due to a coding error in the system. It was not a malicious attack or an employee acting improperly. It was a true error in the system. It allowed cardholders to redeem their gift cards more than once between November of 2013 and March 2014, which resulted in $11.4 million in unauthorized charges. The processor is claiming that the crime policy applies, but the insurer says, well, hey, first of all, this fraud was committed over the phone and not through a computer, and the crime policy requires the crime to be committed through a computer. So there's some interesting issues there as well about insurance coverage for this type of system error.
At this time, we don't have any questions. We would like to thank you all for joining us today and hope that you join us for our next program on April 10th. Should you have any questions after our call, please feel free to reach out to Heather and Chris. Thank you for joining us today.